Welcome to Episode 2 of Fixing America with J Mel. Truth and facts are concepts that form an essential tenet of any democracy. They are the nemesis, the archenemy of a dictatorship. To Trump or any dictator, they are fake news, and they are key to understanding the MAGA/Republican mindset we call the alternate universe. Facts are objective pieces of information that are verifiable through evidence or observation and based on reality. For example, the capital of Texas is Austin, or water is composed of hydrogen and oxygen. Truth is a broader concept encompassing interpretation, beliefs, values, and context. It includes facts and what those facts mean. Truthfulness and honesty are character traits also. Truthfulness is a trait of being consistently aligned with reality. Thus, a truthful statement or conclusion based on facts must be based on facts aligned with reality. A dictator's grip on power depends on controlling the narrative and preventing any information that could undermine his legitimacy. Let that soak in. As the dictator controls the information in his sphere of influence, but not in our world, two universes appears. Ours, the real one, and Trump's, the MAGA one. They live in a world divorced from objective reality. That explains why it is so hard to carry on a meaningful conversation with a MAGA person. And that also explains why facts and truth are an important topic for this episode and this podcast, and help explain the alternate universe and the chaos we find ourselves living in. The fake news mantra is a familiar pillar of the dictatorship-building psychology. It is used to spread flattering or reassuring narratives about the regime, to inspire competence and inevitability. Trump uses it to blame minorities, foreign enemies, and especially independent news media for social problems, incompetence, and to justify repression. And it is commonly used in conjunction with the chaos theory to confuse, make truth-finding harder, and make it easier for followers to dismiss inconvenient facts as fake. Trump's fake news propaganda machine has had the full-throated support of Fox News and several offshoots like Breitbart, Newsmax, The Daily Wire, The Charlie Kirk Show, and The Blaze, along with popular influencers like Rush Limbaugh, Roger Stone, Dean Meek, Jim DeMitt, and Carlson Tucker. Foreign actors in Russia have helped along with armies of trolls, botnets, and paid sharers who boost the stories and keep the narratives where Trump wants them, dominating news cycles. During his term of office, Trump has successfully defunded Corporation for Public Broadcasting and the public broadcasting system. He has vigorously attacked and demonized all the major news networks like ABC, CBS, NBC, and the cable news networks, CNN, MSNBC, I think it's now called MS Now, PBC, and even the foreign news network, Al Jazeera Media Network, and the British Broadcasting Corporation. He has repeatedly labeled U.S. news outlets as enemies of the state. The obvious intent of Trump's actions and attacks on our traditional news media outlets, which have a long history of following high journalistic standards, is to delegitimize them in order to supplant them with his fake news propaganda. The alternative universe phenomenon we find so difficult to understand is merely a natural consequence of his inversion of facts and truth. Understanding that has made it easier for me to cope. The important thing to remember is that facts and truth are extremely important in not only understanding, but developing plans to defend against this tyranny. For that reason, I want to review with you how our legal system deals with facts in its search for truth, and if time permits, discuss truthfulness and honesty, the character traits, and why they should be disqualifying to Trump, his cabinet, and most of his key appointees. I practiced law for 40 years, most of that time as a trial lawyer in both state court and federal court systems. I tried numerous civil and criminal cases to juries. I did appellate work as well. Those cases required that I follow the state and or federal rules of evidence, which are remarkably similar. The rules of evidence are codified rules that evolved over centuries, beginning under the British common law. Virtually every word of those rules has been tested by appellate courts and lawmakers based on challenges which have refined them into, in my humble opinion, for the most part, well-reasoned instruments designed to separate truth from fiction. In the trial court setting, their implementation is laborious and sometimes tedious, but usually effective to reveal the truth when applied along with our other constitutional protections like due process, speedy public trial, right to counsel, right to confront witnesses against you, etc. That process requires the party seeking affirmative relief, the plaintiff, to state a legal cause of action supported by a basic factual allegation that, if proved, would entitle affirmative relief. At trial, the plaintiff must present competent, relevant, authentic evidence, which is not otherwise excluded by the rules of evidence, such as hearsay, privilege, undue prejudice. The proponent of the evidence offered must show that it is reliable, has a tendency to prove or disprove a fact that is of consequence to the determination of the lawsuit, and that it is genuine, that is, it's not forged or altered. Opposing counsel has the right to object to the offer of the evidence, and if that objection is sustained, that means upheld, the evidence is excluded from the trier of fact, that is, either the judge or the jury. A piece of evidence may be admitted generally, that is, for all purposes, or limited only to a specific issue in the case. Each piece of evidence goes through that lengthy process. It may take several pieces of evidence to establish one fact. And if any required piece of evidence is not admitted, a fact may not be established. And if so, the jury would be so instructed. When the plaintiff finishes presenting a piece of evidence through a particular witness, the counsel for the defendant will have an opportunity to cross-examine the witness to undermine the veracity of the evidence admitted or the credibility of the witness. And thereafter, the plaintiff's counsel can redirect testimony from the witness if necessary, and the defense counsel can recross testimony from the witness if appropriate. That laborious process occurs for each piece of evidence throughout the presentation of the plaintiff's case in chief. Thereafter, the defendant is allowed equal time to present a defense to the allegations by calling witnesses and or presenting other evidence through the same process until both sides have exhausted all efforts to prove and or rebut the claims. The trial judge, with the assistance of the lawyers from both sides, then prepare a written charge to the jury, which defines any terms deemed necessary, the applicable law, and submits questions in the form of interrogatories or jury questions designed to make findings on each and every factual allegation necessary to be proven in order for the parties to be granted or denied the relief to which they have sought, together with general instructions on how the juries are to conduct themselves during their deliberations. When the jury returns its verdict, having answered the questions, the factual matters in the dispute will have been deemed resolved. Each party to the dispute had an equal opportunity to present evidence and to test it through cross-examination and the objection process. Every word, document, and scrap of paper involved in the trial is preserved for appeal. In general, if either party is aggrieved by the verdict and feels that justice was not done, they have a right to have a transcript of the entire proceeding prepared and forwarded to the appellate court along with all the physical evidence. On appeal, each side of the dispute is then given an ample opportunity to submit appellate briefs to explain to the appellate court why they believe an error was made in the trial court, the seriousness of the error, and to request appropriate relief as a result thereof. They can also request oral argument before that court. Ultimately, the appellate court will either affirm the trial court judgment, reverse it, or send it back for additional findings or deliberations. At some point, that appeal will become final and eligible for the next step. If either party is not satisfied with the result of that appellate review, they may seek to appeal to the next higher court. If so, they would go through basically the same process before another higher court, limited to the scope of the issues left for review. That is the normal litigation and appellate process. Trump contends to this day that he won the 2020 presidential election. Well, consider this. He went through the foregoing judicial processes at least 60 times in the 60 lawsuits he filed contesting the results of the election. In each of those court proceedings, he had an opportunity to present evidence in support of his claims of fraud or that the elections were rigged, and to contest any evidence presented showing that the elections were fair and accurate. He lost all of those lawsuits. Why? The answer is simple. Because he did not present any competent, admissible evidence in support of his claims. There is no evidence of fraud because there was no fraud. There was no evidence of rigged elections because they were not rigged. Yet he continued to make these spurious, patently false claims. That is fake news and the essence of his alternate universe. We have discussed truth, facts, fake news, alternate universe, and our court system. Considering what we have discussed, ask yourself, are you better off living in a reality-based universe than an alternate universe? And for the purposes of this initial discussion, let's not even include freedom in our discussion. Our current system is broken. That I concede. But in its broken state, it is far superior to Trump's alternate universe, even if you had equal freedom in both. Why? Because in his universe, your conduct would not be judged based on reality. It would be based on whatever Trump decreed reality was. His world could decree that because you are a liberal, you are inferior and should be punished by enslavement. He could say that even if you supported him. He could say that because someone told him that he heard it from someone else whose name he does not know. In an objective world, in a world based on reality, that would not happen because there is no competent evidence to support it. Our court system has problems, but it has many wonderful attributes that work, and the parts that don't work can be fixed. Court systems are complex. They deal with complicated social, moral, and legal issues and are hindered by negative human character traits like dishonesty, cowardice, and greed. Let me share one real example to demonstrate its functional capability. I represented a man charged with aggravated sexual assault of a child. The indictment alleged he sexually assaulted his mentally challenged stepdaughter on multiple occasions during a 2-year period based solely on her statements and the statements of the child's mother. The mother was borderline mentally challenged, as was my client. The mother and my client were estranged. The relationship had been fraught with difficulties. My client simply denied having ever sexually assaulted the child, but his memory to those past events was virtually non-existent. He provided no information to disprove their allegations or form a defense. I concluded he was absent the day brains were passed out. The state had the child's testimony, which would be admissible under Texas law. I could attack her credibility based on her mental acuity, but that is risky and could make the jury turn on me if they feel I was picking on her. The state also had the social worker who had interviewed the child. Her testimony would probably be admissible, and they could possibly admit the video of that interview. The mother's testimony was also admissible as the first person to whom the child made an outcry. Her credibility was questionable, but like the child, her challenged mental condition made her sympathetic to the jury, and my client could not put 3 words together coherently to form a sentence. I could not risk putting him on the witness stand. I did not know if my client was guilty or not, but he did not have a criminal record other than a couple of misdemeanors and was a hard-working day laborer who worked steadily and had a pleasant disposition. Oddly enough, the ordeal did not seem to bother him greatly. I was not sure that he had the capacity to appreciate the magnitude of his predicament. So I sought, and the court granted, a psychological examination to determine if he was competent to stand trial. As I expected, he was found competent to stand trial. I had been over the facts of the case and the testimony of the witnesses with my client scores of times without discovering anything helpful. A few days before trial, I went over everything with my client again without success. Exhausted, I quit visiting with him about the trial and just asked him some general questions out of curiosity. Among those questions was whether he had ever been out of the state of Texas. At first he said, "No," and then he said, "Yeah, a couple of years ago I went to Laramie, Wyoming and worked for a while." Flabbergasted at his response, because that was about the times of the alleged crimes. I tried to pin him down on dates and other information. Oblivious to the significance of my inquiries, he provided no information. But I was excited and promptly returned to office with visions of Perry Mason dancing in my head. I Googled Laramie and learned it was not a large town. I quickly identified a homeless shelter and made contact. Miraculously, they had my client listed as a resident on the dates corresponding to the dates alleged in the indictment. I also learned that he was employed with the city of Laramie, which I contacted. They confirmed his employment and the dates which were consistent with the homeless shelter. I made arrangements with both entities to supply certified documents and appear for the trial if subpoenaed. A short time later, I received the requested information and promptly scheduled a visit with the DA. This type of thing doesn't happen often in a criminal defense lawyer, so I felt compelled to make the most of it with this DA, whom I knew well and had tried many cases against. I entered his office and told him I was ready for trial on this case. As I took a seat, I said, "You know, he is innocent, and I can prove it," as I shoved a folder with the document substantiating my claim across the table. He was in Laramie, Wyoming, during all times alleged in the indictment, and the people at the homeless shelter and the city of Laramie, where he worked, have agreed to honor my subpoena to appear for trial. He compared my documents to his file, and then, with the corresponding file, said, "I'll be damned. This guy is innocent. Give me a few days to confirm it, and I'll dismiss all charges." In Trump's alternate universe, assuming they even had indictments, procedures, courts, and trials, my information could have been simply ignored and pushed aside as fake news. But in our existing judicial system, even with all its faults, justice was done. An innocent man was exonerated. He did not have to serve the rest of his life in prison without the possibility of parole. Could the results have been different? Of course. I got lucky. My client got lucky. But we got lucky because we had a system flexible enough to make luck possible. Thank you for being a part of my podcast today. We did not have time to discuss truthfulness and honesty, the character traits, and why they should be disqualifying to Trump, his cabinet, and most of his key appointees, as I had hoped. Please tune in next time when we tackle that topic and others. And remember to like, leave a comment, start a chat, leave a note, or subscribe. See you at our next episode of Fixing America with J Mel. Please resist and be safe.